The right conferred on religious and linguistic minorities to administer educational institutions of their choice is not an absolute right. Discuss in the light of various Supreme Court decisions. This article explores the extent of state regulation in aided minority educational institutions. It analyzes the decision in the SKMD Rafiq, which goes contrary to the settled law of limited state interference. In matters of selection and appointment of teachers, the state can prescribe only certain criteria to achieve educational excellence in the national interest. However, the impugned statutory provisions have virtually eroded the autonomy that the management board of the institution hitherto enjoyed. The ripples of this decision are far-reaching, given this unprecedented judicial affirmation of virtually unbridled state intervention. State control is necessary to ensure that such institutions maintain basic standards in imparting education. It cannot pave the way for a situation where the board is bound by state recommendations. A moderate state role in such institutions is essential for the preservation of the minority character of institutions under Article 30(1) of the Indian Constitution. A two-judge bench of the Supreme Court of India, hereinafter referred to as the Supreme Court, recently upheld the right of the state to regulate the appointment of teachers to minority educational institutions. In SKMD Rafiq vs. Managing Committee, Kontai Rahmania High Madrasah and others, SKMD Rafiq, a two-judge bench upheld Sections 8, 10, 11 and 12 of the West Bengal Madrasah Service Commission Act, 2008, 2008 Act, which provided that the appointment of teachers in aided madrasas would be regulated through the binding recommendations of a state commission. The Madrasah Committee had contended that the impugned 2008 Act went against the settled principles of limited state intervention in minority institutions as laid down in T.M.A. Foundation and Ors. V. State of Karnataka and Ors. T.M.A. Both the single judge and the division bench of the Calcutta High Court had struck down the provisions for violating Article 30(1) of the Indian Constitution. However, the Supreme Court upheld these statutory provisions, which essentially gives unfettered powers to the state to intervene. The decision in SKMD Rafiq is particularly concerning since it directly contradicts two recent decisions passed by larger three-judge benches of the Supreme Court in Christian Medical College v. Law Association v. Union of India and Chandna Das Malkar v. State of West Bengal. The Chief Justice of India agreed to refer this question to a larger bench of the Supreme Court for consideration. Nonetheless, the constitutional overtones of this decision are worth examining, given that they run contrary to the invariably settled law on state regulation of aided minority educational institutions. This article examines a catena of judgments where the Supreme Court has subjected Article 30(1) to state regulatory power. In Parts I-3, it adumbrates the contours of Indian secularism and describes how the Supreme Court has interpreted the term minority to refer principally to religious and linguistic minorities. Analyzing early decisions, it shows how the court has efficiently balanced state control and minority rights of administration. Part 4.7 demonstrates how T.M.A. affirmed the pre-existing position with comprehensive vigor. In the present decision, the provisions in question have made the recommendations of the concerned state commission binding upon the management board of the concerned minority institutions. The state has the full right to propose certain minimum qualifications in appointments that must be followed by such institutions. However, the issue, in the present case, is the extent to which this power is being used. Once the institution meets the basic stipulations, their decision cannot be subject to state approval, for the same will significantly undermine the concept of autonomy. Judicial interpretation must delicately balance state regulation and autonomy of institutions. The present case is a clear-cut anomaly in that sense. 1. Introduction. At the outset, it is important to clarify that the Constitution does not provide a definition of the term minority. Nonetheless, the recognition of minority rights was viewed as central to the existing corpus of human rights law. They are crucial to prevent the majority community from trampling on the rights of minority groups. Initially, the Constituent Assembly saw fierce opposition to the idea of having a categorization of minorities based on religion. Critics felt that only linguistic minorities should receive protection. However, as Sidhrajbhai observes from these debates, safeguards were to be put in place only for certain minority groups, for political assimilation and improvement of their socio-economic conditions. Eventually, when the framers of our Constitution were discussing this contentious issue, there was consensus over the fact that no state law or regulation, which was prejudicial to the interests of minorities, could be enacted. Ultimately, after much debate, Dr. B.R. Ambedkar drafted Rights for Religious and Linguistic Minorities in a broad sense. Granville Austin encapsulates the objective of inserting Part 3 into the Constitution, when he argues that the purpose of fundamental rights was to equally free from coercion or restriction by the state, or by society privately. Educational rights were guaranteed under Article 30(1) of the Constitution. It provides for all minorities, irrespective of religion and language, to have the choice to establish and administer educational institutions. This was meant to ensure a certain degree of autonomy in using institutional means to promote their culture. Equally, however, the plea of being such institutions cannot be invoked to escape regulation in all cases. Mere state intervention is not an infringement of minority rights under Article 30(1). In fact, claiming legal indemnity in every case would amount to an abuse of the constitutional provision. Either way, legal disputes pertaining to the definition of community-based right make it a clear minority rights issue. The Constitution does not prescribe a definition for the terms religion or language. Yet, minorities can be broadly categorized in two ways: religious minorities and linguistic minorities. The government defines minorities based on the parameters on population, religion, and socio-economic conditions. It cannot be denied that a mere numerical basis of classification overlooks other socio-economic complexities. Such questions have not been comprehensively addressed by the Supreme Court. 1. Minority rights and the Supreme Court, the Indian formulation. In the Constitution, there was a concerted effort by our framers to ensure that fundamental rights, through provisions like Article 30(1), protected the spirit of pluralism. Thus, not only was there a special status for them under the Constitution, but an additional fundamental right, which was to be construed in the widest possible sense. Udit Bhatia aptly clears some misconceptions that exist apropos to minority educational institutions. First, it is not necessary for such institutions to have strong linkages with the religious community based on which it was established and administered. In fact, several institutions exist without any express religious affiliation. Second, there are institutions where minorities constitute only a small fraction of the student population, rather than a clear majority in others. Last, there must not exist an assumption that every such institution necessarily has a religious character. It is only the secular, and not religious, education imparted, which is compulsory for students. There is a clear lack of uniformity as far as their meaning is concerned, since different state and their agencies have established diverse criteria. All such institutions are ultimately bound by fair and reasonable state regulation. These aspects of minority educational institutions must be considered when examining their relationship with the state. India falls within what Hannah Lerner would call the group of countries following the formal, permissive constitutional approach, which allows the constitutional flexibility to reconcile conflicts between the expression of religious identity and promotion of a secular democracy. Our framers envisaged a constitution that would reconcile the deep schisms and conflicts which exist over the fundamental norms and values that naturally arise in society. A preference towards a certain fragility over total determinacy was displayed to ensure stability. Thus, a conscious policy of non-confrontation with contentious religious issues was followed. This was pursued with the hope that evolving precepts, over time, could be gradually incorporated in our constitutional framework. In this nebulous conception, what constitutes permissible state control generally differs from case to case, and needs adjustment depending on the circumstances. Our Constitution does not provide any criteria to differentiate between minority and ordinary educational institutions. Even the 2002 Venkatachalya Commission, while reviewing the working of the Constitution, was reluctant to tinker with the broad wording of Article 30. This was essential not to open a Pandora's box or fuel any potential minority scaremongering. Thus, over time, the task of delineating the scope of Article 30(1) was left to the courts. The Supreme Court sought to protect minorities from executive action, whether at the national or state level, that threatens their minority character. Conscious of the looming threat of such laws being used to suppress non-dominant groups, our framers made Article 30(1) a justiciable right under Part 3. This could hopefully ensure that majority groups do not overshadow the distinct characteristics and individuality of the non-dominant groups, given how minorities live under a psychological fear of being discriminated and overwhelmed. Minority rights, in a broad sense, are collective rights. Yet, there is no uniform definition or basis of categorization. The courts were thus tasked with filling this deliberate omission, since delineating the contours of minority rights were left to their wisdom. They have, on a few occasions, tried to loosely define what it means to be a linguistic or religious minority, though even these dicta suffer from their own set of problems. Hence, by no means does this article overlook the considerable problems that the ambiguity in defining the term minority have brought about. For the purposes of this article, a constitutional basis is being used to analyze how the state regulates minority educational institutions. The Supreme Court has followed the approach of principled distance, given the vagueness in the constitutional provisions protecting minority rights. Rather than a complete disentanglement of the state with religion, the distinctive treatment of minorities in our secular framework does not foreclose the possibility of state regulation. The court has consciously followed the policy of legitimately qualifying minority rights rather than outrightly rejecting them. In matters of appointment of teachers in the Ahmedabad St. Xavier's College Society v State of Gujarat, St. Xavier's, for instance, It has balanced competing interests by allowing the state only to prescribe minimum qualifications and standards to ensure fairness. Nonetheless, certain observations do bring about uncertainty as to the extent of this autonomy. For instance, in the St. Xavier's case, the institution sought autonomy in appointments based on their compatibility with the ideals, aims and aspirations of the institution. The obscurity in such statements only compounds the uncertainty. Shamim Akhtar notes that a common sense view guide the broad judicial understanding of how the terms establish and administer were to be interpreted. If a group of persons belonging to a minority community, usually not a recognizable body, had set up an institution to further their aim of promoting education, the institution was considered to be established. Similarly, minorities were considered to administer the institution if the minorities were the dominant section in the management board. Thus, a conjunctive reading of the two terms showed that a minority educational institution usually cannot be administered without being established. 1. Early judicial pronouncements. As Jaina Kothari puts it, the Supreme Court has broadly held that 1. Minority status depends on the state-wise population. 2. A significant proportion of students should belong to the minority community, and 3. There should be a conjunctive interpretation of the terms establish and administer in Article 30. 1. The last principle was also eventually upheld. In Aziz Basha v. Union of India, in challenging the weirs of statutory provisions, its constitutionality partly hinges on its formulation. Barring the exception in the present case, the Supreme Court has valiantly balanced competing interests while adjudicating on the validity of laws that put constraints on the exercise of minority rights. In Re Kerala Education Bill, Chief Justice S.R. Das, while interpreting Article 30, 1, elaborated on the import of the term choice. He observed, "The key to the understanding of the true meaning and implication of the article under consideration are the words, of their own choice. It is said that the dominant word is choice, and the content of that article is as wide as the choice of the particular minority community may make it. The ambit of the rights conferred by Article 30, 1, has, therefore, to be determined on a consideration of the matter from the points of view of the educational institutions themselves. Observed in the context of subjects and the type of education being imparted, Chief Justice S.R. Das also allowed for the imparting of general secular education, as long as the minority educational institution raised its subjects in a manner that made them eligible for higher education and helped them attain their intellectual aspirations. The choice was inviolable. No limitation was imported into Article 30, 1, provided the aim of educational enrichment was pursued. However, this was never meant to result in a situation where no state intervention was ever warranted. The decision in Kerala Education Bill provides a general idea of how Article 30, 1, is to be construed. First, the term establish has been interpreted to mean bring into existence, whether funded by a single individual or by a community at large. Moreover, the fact that the majority takes advantage of the benefits of these educational institutions is of no relevance. Second, the conjunctive reading of the terms establish and administer means that the right to management can flow as a concomitant right, provided the community has established the institution, whether before or after the commencement of the Constitution. The constitutional aim of unity in diversity could only be achieved by assimilating minorities and discouraging vociferous tendencies. This decision also made it clear that there was no absolute freedom from state intervention, as reasonable regulation could be prescribed to prevent maladministration. A regulation which did not destroy or annihilate the core of the substance of the right under Article 30(1) could be prescribed. The importance of this decision cannot be overstated, for it provides an understanding of how courts evaluated claims under Article 30(1). While the state was to minimize intervention wherever possible, under no situations could educational excellence be compromised. In other words, no minority educational institution could enjoy absolute autonomy in administration, particularly when the quality of education was detrimentally affected. Next, a 6-judge bench, in Rev. Sidhrajbhai, Sabhai and Ors. V. State of Gujarat and Anna. Rev. Sidhrajbhai, adjudged the validity of a statute affecting the rights of minority educational institutions. The impugned order called for majority of the seats in non-government schools to be reserved for government appointees. Moreover, it mandated that the permission of the concerned education inspector be taken to take in more than a certain number of private students. The court was of the view that the concerned government order violated the autonomy in administering minority educational institutions. Justice Shah held that the test of reasonableness could not alone be applied in deciding the extent of state control. Rather than applying a general test, he applied a dual test. First, the statutory or executive action had to be reasonable. Second, it had to regulate the educational character to ensure that the institution effectively imparts education. The court made it abundantly clear that despite the absence of complete autonomy, regulatory measures could not impede the enjoyment of their freedom to administer educational institutions. It expressed its concern that if every single form of interference was justified in the garb of national interest, the right guaranteed under Article 30(1) could never be fully enjoyed. Moving on, the court spoke of the balancing act that had to be undertaken while interpreting Article 30(1). Even the element of public interest was seen as an important factor in adjudging the validity of state laws. Justice Shah noted that merely because Article 30(1) was not unconditional did not mean that the state could impose arbitrary regulations. Only regulations that did not affect the substance of the right, such as those made for the purposes of efficiency of instruction, discipline, health, sanitation, morality, public order, and the like, were permissible. The regulation thus had to be for educational matters. This, of course, has been interpreted widely to pave the way for baseless statutory interventions. In analyzing this test of public interest, measures for the benefit of minorities cannot be completely separated from societal benefit, as the latter is ultimately a subset of the former. What constitutes public interest is very difficult to define. In applying Article 30(1), stringent conditions even on appointment of teachers, though constituting impediments on the choice of appointments, may not be hit by Article 30(1). Laws pertaining to appointments are not completely prohibited. It is only the extent of their application that, like in the SKMD Rafiq case, result in serious inroads into this choice under Article 30(1). For instance, state regulation on the appointment of teachers, if tilting in favor of minority or majority religious communities, would be justified only if a robust link with the objective of educational excellence could be proved. The state could thus impose regulations to maintain educational standards, prevent maladministration and achieve excellence. However, this does not include the right to lay down patterns of admission, management and administration under the label of public interest. With the initiative and dynamism of Article 30(1), other constitutional provisions can adequately safeguard the rights of minorities as well. For the sake of argument, it can even be said that the state can take regulatory measures to secure the interests of academic staff of the institution. However, such measures should be clearly specified and should not undermine, in any manner, the powers of the management board. It has also been argued that the ambit of Article 30(1) has been misconstrued in political rhetoric. The judgment in Rev. Sidhrajbhai did not interpret such rights to supersede even national interest. It possibly used the term absolute only in the larger sense of the term and did not intend for it to be exploited by making Article 30(1) unconditional in nature. Such actions, pertaining to a special group right, must have a relation with the objective of promotion of educational standards or efficiency of administration of the concerned institution or the educational needs of the minority in general. Since the decision in Rev. Sidhrajbhai, the Supreme Court has sought to affirm its stand on this tussle between the state and minority institutions. In Rev. Father W. Proust and Ors. V. State of Bihar and Ors, the Supreme Court upheld the right of choice in matters of appointment of teachers. The court struck down the provision which stipulated that the management body had to go by the recommendations of the University Service Commission on matters of appointment, dismissal or change of rank status of teachers. Similarly, in State of Kerala etc. v. Very Rev. Mother Provincial, the right of appointment of principal was held to be a crucial aspect of the right of administration. Thus, giving the administration of the institution to an unaccountable body was held to infringe Article 30(1). The legislation under challenge sought to make the governing body a distinct entity accountable to the university. This was sought to be done by allowing for nomination of members by the state and the university. This was seen as a material interference in the power of management. Similarly, the right of appointment of qualified headmaster was protected. In Ammad v. Manager, Emjay High School and Ors, the insulation of the protective cover of Article 30(1) was applied, holding that such a right could not be chiseled out through any law, which could only govern basic qualifications and or service conditions. In fact, it was also held that the status of the institution did not depend on any government declaration validating the same. In DAV College, Jalandhar etc. v. State of Punjab and Ors, the Supreme Court confirmed that the definition of minority had to be ascertained with respect to the impugned state legislation, by looking at the state population and not the national population. Although this approach has its problems, our constitution provides sufficient safeguards to protect minority educational institutions. Ultimately, the requirement of affiliation, which called for the establishment of a governing body with university representation, was struck down for violating Article 30(1). Importantly, a 9-judge bench of the Supreme Court, in the St. Xavier's case, held that the impugned provision, which allowed the nominee of the affiliate university to be a part of the selection committee for the appointment of teacher, did not apply to minority educational institutions. It also enunciated the ambit of state control on such institutions. Among other licenses, including decisions on course subjects, faculty employment conditions, health of students and institutional facilities. The right of appointment of teachers was seen as an integral to Article 30(1). Justice Dwivedi observed that as per Part 3 of the constitutional scheme, no absolute rights were conferred on minorities to establish and administer educational institutions. State regulation, in the form of a legislation or an executive order, was permissible if it does not impinge on minority rights but helped facilitate and ensure better and more effective exercise of that right for the benefit of the institutions. The aforementioned decision is questionable, since the scheme aimed to bring about uniformity among governing bodies across institutions. However, this is a rather simplistic understanding of the issue, since it gives the Vice-Chancellor of the university a virtual veto to actions related to termination. Striking down the provision, Justice Khanna observed that no guidelines were stipulated for the veto power by the Vice-Chancellor in nominating an umpire for the industrial dispute resolution process. The selection method was unobjectionable, but this unfettered, final power could not be read into the law. Hence, if the governing scheme itself may possibly lead to the excessive state control in the appointment of teachers, the court was fully justified in not applying it to minority institutions. The pertinent question to be asked, as per Justice Matthew, was whether the measure was purely regulatory or whether it constituted an abridgment of the right. It is hard to view state objectives such as educational excellence and the right of retention of minority character as completely distinct. Given the extent to which maintenance of academic standards overlaps with other aspects of management, this separation brings about an indeterminacy. As noted by Justice Dwivedi in his separate judgment in the St. Xavier's case, there was no hard and fast rule while deciding if a regulatory measure was necessary. Depending upon the context of each case, a reasonable balance had to be drawn between the right to be protected and the public interest being pursued. An important distinction was also drawn in Gandhi Faiz-e-am College v University of Agra, where the concerned university regulation, to confer recognition, required that the principal and the senior most teacher had to be associated with the governing body. Justice Krishna Iyer pertinently observed that a mere marginal impingement on the administrative setup to prevent mismanagement does not violate Article 30(1). However, a certain degree of circumspection must be present when conferring unbridled power through the complete restructuring of the composition of the governing body. In All Saints High School v Government of Andhra Pradesh, All Saints, the Supreme Court rightly held that the state could regulate the service conditions of teachers. In fact, even a higher authority could be appointed, which, with sufficient guidance, could ensure rule compliance. However, no such statutory authority could be armed with unbridled and arbitrary powers such that it would undermine the autonomy of the management board of the institution itself. The court even suggested that the members or a nominee of the governing body of the institution be included in the deliberations. This would help maintain trust and confidence, and also introduce a certain degree of transparency in the dialogue process. Thus, both in St. Xavier's and in All Saints, the court was not in favor of complete freedom from state regulation, since it was essential to maintain the educational character and content of minority institutions. This dictum was supplemented by the decisions in Bihar State Madrasah Education Board v Madrasah Hanfia Arabic College and Committee of Management, St. John Inter College v Girdhari Singh and Ors. Both decisions cemented the position that in examining the validity of state regulations, it had to be seen whether there was any guiding set of principles that were not unreasonable. In fact, the existence of any such regulation was seen to constitute a virtual surrender of the right to administration. In these decisions, the Supreme Court has not, by any measure, foreclosed the possibility of state intervention. In fact, a certain degree of state interference is encouraged to maintain educational standards. However, the scope of this role was to be narrow and only for the tailored purposes, without usurping the role of the management board of these institutions. 1. An endorsement of limited state intervention, the T.M.A. case. An 11-judge bench, in T.M.A., enunciated the general principles of regulation of minority rights by expressly upholding the right of minority educational institutions to select their governing bodies, teachers and staff, and exercise disciplinary control over them, and a right to fix reasonable fees and admit students in a fair and transparent manner. It defined minorities as a group held together by ties of common descent, language or religious faith and feeling different in those respects from the majority of inhabitants of a given political entity. They were described as a non-dominant group having different religion or linguistic tradition than the majority population. The mere absence of a definition did not mean that the term minority carried any less importance. There was adherence to the formula of using population of the concerned state to ascertain minority status. In deciding claims of minority communities, the court, after verifying numeral non-dominance, looks only at certain identifiable characteristics that make them religious or linguistic minorities. The Supreme Court, keeping in mind the decisions in Kerala Education Bill and St. Xavier's, wanted to ascertain the true scope and interpretation of Article 30(1). The term choice was given the widest possible interpretation in the determination of education and educational institutions. Despite minor disagreements, the majority verdict arrived at a consensus in holding that Article 30(1) was not absolute. It was clarified that this provision guaranteed no special right but was only a special safeguard for certain specified educational purposes. State regulation could be warranted only in proposing the selection and appointment methods through the prescription of minimum qualifications. Despite this broadly unfettered right to run educational institutions, the state could impose regulatory measures to maintain educational standards in the national interest, as long as it did not become a government-owned and controlled institution. At first blush, the salience of this decision is evident insofar as it justified the constitutional basis of state regulations by locating it within Article 19(1) g. The legal distinction that the court, in Rev. Sidhrajbhai and Unni Krishnan, J.P. and Ors. V. State of Andhra Pradesh and Ors. drew between reasonable restrictions under Article 19(6) and the power of the state to impose regulations under Article 30(1) was dispensed with. Classifying education under the category of occupation, this right was seen to emanate from Article 19(1) g. Limited state intervention under Article 19(6) was permitted in matters including appointment of teachers. The bench also chose to discard the observation made in St. Stephen's College v. University of Delhi, St. Stephen's, which gave full freedom to such institutions, if half of the seats were reserved for non-minority students. They opined that rather than a rigid 50% percentage mark, the number of seats would depend on the size and needs of the minority group along with the level of the institution. The onus of proving minority status was put on the minority community itself. It was also made abundantly clear that state regulation in national interest would override the right under Article 30(1). Moreover, such regulation applied to all educational institutions. In the St. Stephen's case, even the standards of education were held to fall outside the domain of the right to management. The state has the right to ensure that such institutions do not fall below the general standards of excellence in the guise of minority rights. However, it must not result in total state control over how the institution is to be managed. Before briefly discussing the problem with T.M.A, it is worth reproducing Article 19(1), G, 19(6), and 30(1). 19 Protection of certain rights regarding freedom of speech, etc. 1. All citizens shall have the right G. to practice any profession, or to carry on any occupation, trade or business. 6. Nothing in subclause G. of the said clause shall affect the operation of any existing law in so far as it imposes, or prevent the state from making any law imposing, in the interests of the general public, reasonable restrictions on the exercise of the right conferred by the said subclause, and, in particular, 1. Nothing in the said subclause shall affect the operation of any existing law in so far as it relates to, or prevent the state from making any law relating to, I. the professional or technical qualifications necessary for practicing any profession or carrying on any occupation, trade or business, or 2. the carrying on by the state, or by a corporation owned or controlled by the state, of any trade, business, industry or service, whether to the exclusion, complete or partial, of citizens or otherwise. 30 Right of minorities to establish and administer educational institutions. 1. All minorities, whether based on religion or language, shall have the right to establish and administer educational institutions of their choice. In this context, it is important to understand how the T.M.A decision unintentionally paved the way for excessive state intervention. While the right to administration had been hitherto enjoyed under Article 30(1), it was sought to be justified as an occupation under Article 19(1), G. Given that Article 19 is an explicitly conditional right which allows state intervention under subclause 6, it became easier to justify state intervention. By relying on Article 19(6), the state could now impose reasonable restrictions that were in the interest of the general public. Furthermore, through Article 19(6)(I), the state could now enact laws to enforce the necessary professional and technical qualifications for undertaking to carry on the occupation of administering such institutions. The scheme of Article 19, when compared to Article 30, is such that it allows for conditional constitutional freedoms. It is important to understand how the T.M.A decision unintentionally paved the way for excessive state intervention. By placing the right of administration under Article 19(1), G, it considered this right as an occupation, and it became easier to justify state intervention under Article 19(6). The scheme of Article 19 is such that it allows for conditional constitutional freedoms. If Article 19 had not been employed, we would not have seen such brazen departures from the approach of minimal interference. The trend of excessive state control in Article 19 could possibly be seen as the basis behind these encroachments. In locating state regulation within Article 19, 1g, rather than simply basing its intervention under Article 30, 1, the court has inadvertently opened the room for misinterpretation. Perhaps, the T.M.A case may have unintentionally spawned a departure from the settled position. As Fali Nariman concurs, the problem of maladministration of institutions, as was the case there, has been used to deprive them of these rights. State interference is justifiably necessary in some cases. However, this must not be every time, particularly in the absence of concrete and solid proof of the averments. Even with the clarity that T.M.A brought in locating the source of state regulation in the Constitution, it may have been somewhat responsible for this present deviation. It has relegated minority rights from one of the preferred freedoms to a mere occupation under Article 19, 1g. This has led to a debasement of this broad right, making state regulation much easier. Subsequent decisions have only bolstered this stand. For instance, the decision in Brahmo Samaj Education Society and Ors. We State of WB and Ors is a direct case at hand. Here, the Supreme Court reiterated that once the basic qualifications for teachers' appointments are prescribed, the management board had the exclusive right of selection among the qualified and eligible teachers. The state could not take over the control and administration of the institution. Any such incursion into this right would amount to the state controlling the day-to-day administration. In conclusion, the T.M.A decision reaffirmed the general principles of minimal state interference in minority educational institutions. The problem was that in protecting minority rights based on Article 19, 1g, it made excessive state intervention unintentionally easier to justify. 5. Critiquing the scope of state regulation in the context of the SKMD Rafiq case. Analyzing the aforementioned gamut of decisions, rights under Article 30, 1, have been protected by the Supreme Court. PM Bakshi supports regulatory measures for the purposes of smooth working and educational excellence. In analyzing the approach of the Supreme Court, he notes several trends which may be applicable in theory but become contentious areas in their practical application. For instance, it is a truism that right to administration only includes good administration and not maladministration, which minority institutions are duty-bound to provide. However, if the state and the minority educational institution are at variance with what good administration is, problems may arise. Similarly, differentiating between the direct and indirect impact of a law, with the latter only having an incidental impact on minority rights, can be problematic. Again, there is no accurate way of ascertaining which impact is direct and which is not. Thus, pragmatism needs to be exercised in arriving at a harmonious construction. Minority institutions possess the choice insofar as their relations with the state on issues like courses, curriculum and the appointment of teachers are concerned. The level of regulation that is acceptable is when the state prescribes minimum qualifications, such as those promulgated by the University Grants Commission, UGC. However, selection of teachers becomes a sphere of operation purely within the domain of the minority institution itself. There must be a liberal construction of Article 30, 1, to prevent its application from undermining other fundamental rights. This was seen in the dissenting opinion of Justice Beg in the St. Xavier's case, where he observed that Article 30(1) could not be employed to exact unjustifiable preferential or discriminatory treatment for minority institutions so as to obtain benefits but to reject obligations of statutory rights. Thus, Parmanand Singh may be correct in contending that inordinate concessions result in the creation of a privileged class, which may have separatist tendencies, and even pose an impediment to national assimilation. However, his argument of an increased state role may be extreme. He argues that the role of the state must go beyond mere prescription of standards, and may extend to all necessary measures to orderly, efficient, and sound administration of such institution. Every institution must only be bound, in the very words of Singh, by reasonable statutory demands regarding the service conditions of teachers and all allied matters. In other words, arbitrary powers of the state must not replace management powers of the board of the institution. This may mean that the state may act through the agency itself to secure a fair procedure. However, there cannot be a degree of control which results in administration by the state. Coming to the SKMD Rafiq case, a conjoint reading of the impugned provisions shows that the Commission was entrusted with the role of selection and appointment of teachers at the expense of the management board. In fact, failure to adhere to this procedure would render the appointment by the management board invalid. Their failure to appoint teachers in accordance with the recommendations would attract disciplinary proceedings and possible derecognition or withdrawal of affiliation. Thus, the management was bound by such recommendations. Looking at the 2008 Act, it is necessary to reproduce the impugned provisions. 8. Notwithstanding anything contained in any other law for the time being in force or in any contract, custom or usage to the contrary, it shall be the duty of the Commission to select and recommend persons to be appointed to the vacant posts of teachers in accordance with the provisions of this Act and the rules made thereunder. 1. Notwithstanding anything contained in any other law for the time being in force or any contract, custom or usage to the contrary, the managing committee, the ad hoc committee or the administrator, as the case may be, shall be bound to appoint the candidate recommended by the Commission to the post of teacher in the Madrasah concerned as per vacancy report. Provided that in the absence of the managing committee, ad hoc committee or the administrator, the headmaster or the headmistress or the teacher in charge is empowered to issue appointment letter to the candidate recommended by the Commission. Such matter should be ratified at the next available meeting of the managing committee, ad hoc committee or by the administrator, as the case may be. Provided further that the managing committee, ad hoc committee, the administrator or the headmaster or the headmistress or the teacher in charge as the case may be, shall, if any error is detected in the recommendation, immediately bring it to the notice of the Commission for removal of such error. 1. Any appointment of a teacher made on or after the commencement of this Act in contravention of the provision of this Act shall be invalid and shall have no effect, and teacher so appointed shall not be a teacher within the meaning of Clause S of Section 2. I. If the managing committee, the ad hoc committee or the administrator of a madrasah, as the case may be, refuses, fails or delays to issue appointment letter to the candidate recommended by the Commission within the period stipulated in the letter of recommendation by the Commission, without any reasonable ground, the state government may direct the board to dissolve the managing committee or the ad hoc committee, or discharge the administrator, as the case may be, or stop all financial assistance to such madrasah recording reasons thereof, and may also issue direction upon the board or council, as the case be, to withdraw recognition or affiliation of such madrasah. 2. In case of failure to issue appointment letter to the candidate recommended by the commission is on the part of the superintendent, the headmaster, the headmistress or the teacher in charge of a madrasah, he shall be subject to such disciplinary proceedings as may be prescribed. 1. Notwithstanding anything contained elsewhere in this Act, the terms and conditions of service of teachers in the employment of a madrasah immediately before the commencement of this Act shall not be varied to the disadvantage of such teachers in so far as such terms and conditions relate to the appointment of such teachers to the posts held by them immediately before the commencement of this Act. It becomes clear from these provisions that the primary responsibility of appointment was entrusted with this statutorily appointed commission. The concept of error in the proviso to Section 10 is worth discussing. The second proviso mentions how any error in the recommendation of the commission can be pointed out to them by the managing committee. This also covers situations where the managing committee feels it could appoint a teacher that is more qualified than that recommended by the commission. In such cases, the commission would have to act on the notice of the managing committee. A wide meaning has been given to this concept. However, problems arise if the commission feels it has not committed an error. Thus, even if such errors are rightly put to the notice of the commission, it can be easily rejected. In such cases, the commission becomes the final arbiter of its own decision that comes to be challenged. Section 12 provides a degree of protection by allowing the managing committee to refuse the recommendation made by the commission on reasonable grounds. What grounds meet this threshold, however, remains unspecified. The court held that if the managing committee could appoint a better qualified teacher, refusal of the recommendation of the commission would be a reasonable ground. However, more statutory guidance on the same is needed. Moreover, the managing committee of the minority educational institution was bound to act as per in recommendations. In fact, a strict prospective application of this law resulted in power being taken away from the management altogether. Section 11 is evidence of this adverse and rather unwelcome consequence. Any appointment that purportedly infringes the Act has no value. This may lead to a situation where, for instance, the decision of the management to appoint a faculty member may be rendered void. An inordinately broad latitude has been given to this statutory body, resulting in the possibility of serious abuse of Article 30(1). Worse still, Section 12 threatens to take all autonomy away from minority educational institutions. Its application can result in a disastrous situation where a legitimate conflict regarding appointments can lead to state governments authorizing the dissolution of the management altogether. The wording of the provision allows for dissolution not just in cases of refusal or failures to appoint but also in case of delays. Alongside dissolution, other ramifications include withdrawal of aid, recognition, affiliation, and even the commencement of disciplinary proceedings. The present judgment also relied on the Frank Anthony Public School Employees Association v Union of India and Ors. Frank Anthony, which held that institutions had the right to appoint a governing body in which they had confidence and trust, as well as the right of appointment of teaching and non-teaching staff. The Frank Anthony decision also held that state interference was warranted as far as it related to basic qualifications, service conditions, grievance redressal and proper aid utilization. The SKMD Rafiq judgment placed reliance on the Frank Anthony decision to delineate the limits of state intrusion. It held that Section 12 of the Delhi School Education Act, which made certain provisions of this legislation inapplicable to unaided minority educational institutions, was discriminatory. The court opined that the conditions of service, including salaries and allowances, directly influenced the service conditions rendered at the educational institutions. In this way, it was able to reconcile its view in favor of autonomy without disregarding the need for occasional state intervention. T.M.A. has thus been used to hold that state regulation in national interest, provided it did not threaten the minority character, was not unjustified. However, the impugned provisions do not fall within the ambit of permissive regulation. There is a clear misinterpretation of T.M.A. in the SKMD Rafiq case, as the mechanism for selection of teachers to achieve educational excellence is very different from making recommendations binding on the management board. The reasoning of the court evinces a disconcerting suspicion towards the ability of madrasahs to impact general secular education. Again, the facile assertion that qualitatively better teachers will ensure higher educational standards has been employed to substitute the wisdom of the management with its own. The court showed no hesitation in treading into areas even beyond the prescription of a minimum qualification. It erroneously held that in the bracket beyond just the basic qualifications, the state could intervene if the management does not appoint teachers with higher qualifications than others. This, while being a legitimate concern, is beyond its jurisdiction. In their view, subjective choice in selection, beyond the initial threshold, is also not excessive, if the measures are in pursuit of educational excellence. To make it clear, the court holds, if there is a better candidate available, the minority institution cannot exercise its choice in selecting a lower-placed candidate than the better-placed one, albeit both cross the basic requirements. The example of a minimal percentile index for appointment helps explicate the point in the preceding paragraph. It says that even if the numeric threshold needed to be considered for appointment is crossed, the failure to appoint someone with a higher ranking in that range shall also become a hindrance in the pursuit of educational excellence. This erroneously gives the state a carte blanche to intervene even beyond setting the minimum criteria. This is because the statutory commission can almost feel entitled to regulate appointments. Ideally, once the threshold has been set, the minority institution should be free to appoint teachers even with a lower percentile index than others. Otherwise, the institution risks perpetual state intervention. If such statutory bodies can intervene to choose between candidates that cross the threshold for selection, it is, in essence, displaying a complete disregard for that threshold itself. These are matters squarely within the domain of the educational institution, upon which very limited state intervention is warranted. It is completely unacceptable for the recommendations of the Commission to be binding upon madrasahs. The only leeway that the impugned statute in the present judgment gave was in giving the managing committee the chance to bring any error in appointment to the notice of the Commission. This is because the Commission is under no compulsion to accept the notice and correct the error. It will be unlikely that with this amount of influence in appointments, the Commission would be heedful of any errors pointed out to them. The only right of refusal that can be exercised by the managing committee must be based on reasonable grounds, without specifying how the same is to be arrived at and by which authority. In fact, Ranu Jain accurately observed certain trends in the judicial interpretation of Article 30. While it must be admitted that the contextual decisions in cases involving varying factual scenarios has made the ambit of Article 30, 1, extremely vague. In principle, I disagree with Jain when she argues that the objectives of achievement of excellence and uniformity, along with prevention of maladministration, provide too much space for governmental interference. However, it would be unreasonable to say that both the space and tolerance for governmental interference was excessive. Before the decision in T.M.A, the Supreme Court broadly balanced the competing interests of minority rights protection and the larger right of state intervention in national interest. However, in the present case, the state has sought to take over the process of appointments altogether, which presents a dangerous trend. The problem stems purely from how the state has misused this leeway to intervene. Fazan Mustafa rightly argues that the West Bengal Board of Madrasah Education Act, 1994 and the 2008 Act conferred excessive powers on the state vis-à-vis minority educational institutions. The establishment of a state commission to regulate the appointment of teachers virtually erodes the autonomy in administration that the management committee hitherto enjoyed. For instance, a conjoint reading of sections 10, 11 and 12 of the 2008 Act make it amply clear that the management committee is essentially bound by the recommendations of the commission. It also allows the state to invalidate any appointment made in contravention of this provision. Lastly, grants can be denied to institutions for refusing to appoint teachers in accordance with these recommendations. Mustafa calls for court intervention and mentions grounds like health, sanitary and municipal regulations, and advocates for the validity of reasonable regulations in the prescription of minimum standards. Contrary to what was argued by even Dr. B.R. Ambedkar, the Supreme Court has recognized that Article 30, 1, is not an absolute right. Thus, it cannot be denied that Article 30, 1, can be subject to state intervention. The bone of contention is the basis on which the state chooses to interfere. 6. The larger implications of an intrusive state. Minority institutions have enjoyed a privileged position in terms of state supervision, given the generous interpretation of the Supreme Court on Article 30, 1. Strict supervision cannot be undertaken for such institutions, and regulations can be enacted within extremely narrow limits. Striking a balance between guaranteed constitutional rights and public interest, such as excellence in terms of the academic advancement and standards of organization, presents its own challenges in a democracy like ours. As Anil Kaushik summarizes, Article 30, 1, was meant to serve as a shield for minority educational institutions against the invasion of certain rights protected by it. There are certain fears that the state has concerning minority educational institutions, which cannot be discounted. These include the possibility of fomenting communal troubles, dominance of subgroups within the community, excessive interdependence among members, lack of exposure to alternate cultures, presence of negative stereotypes against certain members, institutional usage for mass mobilization and vulnerability to fundamentalist elements. However, to direct such legitimate fears to institutions alone would be unfair, given that these are deep-rooted fears in society in general. The state, to some extent, is justified in its concern about possible misuse of Article 30, 1, as it may be used to surpass or simply ignore existing rules and regulations. State intervention is needed when this fundamental right is used to circumvent government requirements rather than benefit the community. However, this cannot mean that the state arbitrarily exercises its power. Such institutions must be given a certain amount of freedom to locate and resolve the problems that it is facing. No minority educational institution is bound by government procedures on the appointment of the principal and/or teachers. Matters of appointment of teachers fall within the rubric of what is referred to as matters of internal administration. In these situations, such standards and prescriptions should only further the purported aims and should not deprive the founders of the institution to manage and mold the institution according to their need, desire, and object. The exercise of absolute powers has resulted in misuse of this regulatory license given to a statutory authority. This goes against the very spirit of autonomous minority educational institutions. Holly Cullen, albeit in a different context, postulates a theoretical framework to resolve what she sees as a seemingly ineluctable clash between education rights and minority rights. In deciding whether minority education rights fall within the rubric of minority rights or education rights, she proposes that minority education rights be treated as a subset of education rights rather than minority rights. In her view, if minority education rights are viewed as a species of minority rights, the objective of educational excellence would give way to the protection of the cultural aspects of the concerned minority group. However, this approach creates an artificial and unnecessary distinction between minority rights and education rights. Courts in India have made it unequivocally clear that state intervention in the administering of minority educational institutions is not completely precluded. Keeping this in mind, minority rights and education rights need not be seen as distinct. Rather than operating in mutually exclusive spheres, minorities can run educational institutions with the dual objective of promoting educational excellence as well as protecting minority values. Normatively, if any of these are threatened, the state can always intervene to ensure that one aim is not overshadowed or undermined in promoting the other. This approach would promote the values of pluralism and aim to ensure equality of opportunity in running these institutions.